Racial disparities have been a feature of the death penalty throughout the history of the United States. Of course, the death penalty was used so much in the South during the time of slavery and also after the Civil War during the time of Jim Crow justice, lynchings, and racial oppression. And today, still, there are racial disparities in the infliction of the death penalty. Warren McCleskey, who was sentenced to death in Georgia, challenged racial disparities in the infliction of the death penalty in Georgia in a case, McCleskey versus Kemp. That's what we're going to start off talking about today. Just to sort of set the stage, in Georgia, 27% of the population is African American. Look at this, 65% of the victims of murder are African American, yet 80% of the people on death row are there for the murders of white people. Clearly, Georgia punishes the murder of a white person much more severely than it does the murder of a black person, regardless of who commits a crime, whether the person is black or white. Murders of African Americans are not treated with the same degree of seriousness by the courts. Georgia prosecutors seek the death penalty in 70% of the cases where the defendant is black and the victim is white. 32% of white defendants on white victims, 19% white defendants and black victims, and then 15% where it's black on black. So you can see the top two here, the white victim has a very prominent role in keeping this number above 20%, as well as the race of the defendant. In terms of the imposition of the death penalty, 22% black defendant, white victim cases the death penalty is imposed on those cases. Only 8% where it's a white defendant and a white victim, and then 3 and 1% for the other racial combinations. The Balda study was actually two studies, often referred to as the Balda study as if it was just one, but there were two, the procedural reform study and then the charging and sentencing study. And the second, the charging and sentencing one, is the one that's really important. One of the criticisms that have been made of studies of the death penalty and of racial disparities was there were all these variables that weren't taken into account, that if you just said of all the people that were sentenced to death in the commission of a robbery, the number of blacks was much greater than the number of whites, people would say, yes, but there are a lot of other factors that have to be considered. And what this study tried to do was take those factors into account. A total of 230 variables were taken into account. This is probably the most sophisticated study of sentencing that has ever been done. About 2,500 Georgia cases. This was from when the death penalty was reinstituted in Georgia until the time that the study was done. And they found about 1,600 people were eligible for the death penalty, but only 128 actually were sentenced to death. So you see the tremendous difference in the number of people who could have received the death penalty, but only 8% of the people did. So the question was, what were the factors that influenced how this narrowing took place from going to 1,600 to 128? And to what extent, if any, did race play a role in that? Warren McCleskey was prosecuted in Fulton County, that's Atlanta, Georgia, and of the 17, he was charged for killing a police officer. Warren McCleskey was African American. The police officer was white. Of the 17 people arrested for murder of a police officer between 1973 and 79, which is when this study was conducted, only McCleskey was sentenced to death. The Baldus and his colleagues who did the study performed a rigorous multiple regression analysis to try to take all these 230 variables that they had found and see how they factored into the process of who got the death penalty and who didn't. To what extent things that were legally relevant may have factored in, like multiple victims, or crime against a stranger, or torture. But also to what extent did non-legal factors like race come into play. After running the multiple regression analysis and looking at different aspects of this, the researchers concluded that a white person, an African American like McCleskey, who's charged with the murder of a white person, is 4.3 times more likely to be sentenced to death than other racial combinations. McCleskey raised two claims. One, that there was intentional racial discrimination against him because of his race and because of the race of the victim. McCleskey's lawyer, John Charles Boger, at the NAACP Legal Defense Fund, when he stood up before the court to make the argument for McCleskey, he said, if we had a law that said the death penalty could only be imposed in cases where the victim was white, it certainly would be unconstitutional. In fact, at one time in our history, the punishment for crimes did vary based on the race of the victim as well as the race of the defendant. But of course today, that would not be, and at the time of McCleskey's case, that would not be a permissible basis for distinguishing which cases got the death penalty and which did not. So his argument was race discrimination, intentional race discrimination came into play. And then he made a second argument based on the cruel and unusual punishment clause of the 8th Amendment, in which he said there was an impermissible risk, not necessarily intentional, but that there were so many discretionary decisions being made, so many people had so much discretion that by the time the death penalty was or was not imposed, there was too great a risk of the death penalty of race influencing who received the death penalty. This was what Justice Douglas had found in Furman versus Georgia. And that was the reason for his vote to strike down the death penalty in Furman versus Georgia, was that there was so much room for discretion to come into the process that it did not eliminate the risk, or it didn't minimize the risk of race and poverty coming into play. With regard to the first claim, the equal protection claim, the court set a very high standard of proof, that Warren McCleskey had to prove that the decision makers in his case acted with discriminatory purpose. That unlike jury challenges to jury pools, where you look at the number of people in the population and say it's 50% African American, and you look at the jury pool and it's 30%, and you infer from that that there's discrimination or employment cases, the decision to impose the death penalty is made one jury at a time, and each jury is an ad hoc body that comes together and makes that decision one time. Really, the decision making that results in these disparities is decision making by prosecutors. The two most important decisions in every death penalty case is, one, does the prosecutor seek the death penalty to begin with? Most of the time they don't. Many prosecutors never seek the death penalty. Some other prosecutors seek it every opportunity. So there's wide variation, and each prosecutor is elected in most states from a different judicial district. So the practices in one district can be completely different than the practices in another. The second critical decision is whether to plea bargain the case and resolve it with a sentence other than death in exchange for the defendant pleading guilty and waiving a trial. And that's where the overwhelming majority of capital cases are resolved. And they're resolved obviously without the death penalty being imposed, because either the prosecutor doesn't seek it or because the prosecutor offers a plea bargain and the case is resolved with a plea bargain. But what about the times when the prosecutor won't offer a plea bargain and the cases are taken to trial? The Supreme Court, as it had done in other cases of selective prosecution, sets a very high standard for trying to challenge the decisions being made by prosecutors. That exceptionally clear proof, because of the value of discretion, which can work in the defendant's favor if the prosecutor is merciful, or it can work adversely if the prosecutor decides to seek the death penalty. Exceptionally clear proof, and we don't know how clear it has to be because nobody has made this standard yet, has proven this yet. Exceptionally clear proof is required to infer that there's been race discrimination. In other words, the person challenging the decision has to be able to show that the decision was because of race and not merely in spite of it. And the court has done this in other cases. Before McCleskey's case in a Waite versus United States, a number of people who had burned their draft card were charged with evading the draft. When they were prosecuted, they said, well, wait a minute, there were 600,000 people who didn't register for the draft, and we're the only ones who got prosecuted, and it was probably because we burned our draft cards. And so we're being discriminated against because we exercised our First Amendment right to protest. Supreme Court rejected and said, you have to show that because of your exercise, not merely in spite of, that the prosecutors singled you out. It's pretty obvious that the prosecutors had, but basically what that decision has done and subsequent decisions is pretty much insulate from any judicial review decisions made by prosecutors in terms of whether to seek the death penalty and whether to resolve cases with plea bargains. We'll also see that it's difficult for defendants to make that challenge because often the information that is needed is just simply not available. With regard to the Eighth Amendment challenge, the question was, is there some risk of race playing a role? There are risks that other kinds of prejudice will influence criminal trials, but the question about race is, at what point does the risk become constitutionally unacceptable? So those were the questions that were before the court to look at both of these. Let's first look at what the court said about the statistics. Justice Powell wrote for the majority, the 5 justices. This was a 5-4 decision. Justice Powell, writing for the majority, says, at most, the Balda study indicates a discrepancy that appears to correlate with race. And then goes on to say, disparities in sentencing are inevitable, which is one of the most striking lines in the McCleskey opinion. I guess the court in Brown versus Board of Education could have said differences in the kind of education children receive at school are inevitable. So we'll allow separate but equal to go on. The court didn't do that in the Brown case, but it did do it in the McCleskey case. Basically saying that we are not going to assume that one is unexplained, that these disparities that we see, because discretion is so important to our criminal justice system, that prosecutors have discretion, that juries have discretion, that because that's so important, we're not going to assume that what is unexplained is invidious. Basically, all the evidence is pointing to one reason for this, and the Balda study certainly isolated reasons for this, but the court said we're not going to assume that race was the factor that caused Warren McCleskey to be sentenced to death or that influenced the decision. It doesn't have to be the only reason, but that Warren McCleskey got the death penalty. The court also said, in light of the safeguards that the court had adopted to minimize racial bias, the value of the jury trial and the benefits of discretion, again back to the benefits of discretion, the court holds that the Balda study does not demonstrate a constitutionally significant risk of racial bias. There's a risk of racial bias. It's pretty well established by the study, but the court concludes that it's not constitutionally significant in terms of affecting the capital sentencing process in Georgia. The court also says it's not discriminatory or disproportionate when applied to Warren McCleskey, because McCleskey committed a crime for which the death penalty could be imposed. Of course, if there's no problem anytime a person is sentenced to death for a crime for which the death penalty can be imposed, then you stop right there and that's the end of the inquiry. But as we saw earlier, out of 1,600 people who were eligible for the death penalty, only 128 received it. So a lot of decisions and discretion is being exercised to get down to the people like Warren McCleskey, who ended up in that 128 who were sentenced to death, and not in the hundreds of other people who were not sentenced to death. Justice Powell also says that the sentence in this case was consistent with the procedures that Georgia has for imposing the death penalty. These were upheld by the court, and Gregg versus Georgia in 1976. One of the arguments McCleskey had made is that everybody in Georgia discriminated, the legislature, the governor, the juries, the prosecutors, everyone. The court said, you can't say the legislature discriminated because we upheld the Georgia statute in 1976. Of course, that was upholding the statute as written, but not as applied. And McCleskey's challenge was, now that we've seen this statute in operation for some period of time, what we're seeing are these rather dramatic racial disparities, 4.3 times more likely to get the death penalty if you're a black man like Warren McCleskey and the victim is a white person. But the court says, because he could have received the death penalty because this is under the statute which allows the death penalty if there's a homicide and aggravating circumstances, we're not going to assume that the death penalty was wantonly and freakishly imposed in this case. Two other considerations the court mentions. One, that if McCleskey's case was taken to its logical conclusion, it would throw into question the entire criminal justice system. That if we looked at race bias in the imposition of the death penalty, we could be soon confronted with claims that there's race discrimination in other kinds of sentencing, and there certainly is. We know that there's race discrimination in penalties for drug use, for example. And basically the court is saying if we start looking at race in death penalty cases, then we might have to start looking at race in all kinds of other criminal cases where it appears that the sentencings are more severe as applied to African Americans or Hispanics or whoever than applied to whites. Justice Brennan called this the fear of too much justice. And others could argue that if there are those racial disparities, which there are, throughout the criminal justice system, what the courts ought to be about is dealing with them, not sweeping them under the rug by having a standard of proof that no one can meet. But that's what the court did in this case. Justice Powell even goes on to say, hard to understand this, that it could even be applied to other characteristics such as gender. Of course, normally we don't allow discrimination on the basis of gender, but he goes even further than that to say that if McCleskey's claim is sustained, we might even apply it to facial characteristics or physical attractiveness. Now, Justice Lewis Powell lived in Richmond, Virginia, which was the capital of the Confederacy at one time. He surely knew that African Americans had been subject to discrimination throughout the history of this country and were still subject to discrimination that was in no way comparable to people based on their facial characteristics or based upon their physical attractiveness. So it's a striking line in the opinion that he would say that a claim based on race is as trivial as a claim based on physical attractiveness or facial features. He says there's one other factor, and that's that this is best presented to the legislatures, that they can weigh the studies and the information and they can decide what's appropriate. Of course, the problem is that legislatures are very driven by the majority, and if someone's constitutional rights are being violated, the buck really stops with the courts. It's the courts that would have to step in and do something about race discrimination. It's unlikely that particularly when you have states like Texas and Georgia and Alabama and others where the death penalty is immensely popular, that those states are going to look at the death penalty and decide that they're not going to impose it. Although, as we will see, one state, North Carolina, did pass a law to look at race disparities and the influence of race in capital sentencing, and what they saw was not very favorable with regard to the fair infliction of the death penalty in North Carolina. Justice Brennan, in his dissent in this case, says, at some point Warren McCleskey undoubtedly asked his lawyer what the chances were that he was going to get the death penalty. He says an answer to that question would have to be disturbing because the lawyer would have to tell McCleskey that nothing about the fact of his crimes, nothing about his own personal background, his prior record, would be as influential in terms of whether he received the death penalty as his race and the race of his victim. It's a remarkable thing that William Brennan, in his lofty perch on the Supreme Court of the United States, could so clearly understand conversations that lawyers and people facing the death penalty have in jails all over the United States. He said those conversations, which continue until this day, would be the most eloquent dissents to the McCleskey opinion of all. The question then is there a remedy after McCleskey for race discrimination? One of the first cases to present this was another Georgia case of a fellow named Wiley Dobbs, who was sentenced to death in Walker County, Georgia. Here was a case where powerful evidence that everybody involved in the case, the jurors, the prosecutor, the defense lawyer, the judge, that there were these racial attitudes. The community had this history of race. And yet, Dobbs lost. The court ruled against him. He said on the first prong that he hadn't proven intentional racial discrimination, and we've talked about why, and McCleskey, why that is almost it is impossible to prove after the McCleskey case. And then the court said, with regard to the risk of race playing a part in Dobbs' case, that as long as these procedures existed, such as procedures prohibiting discrimination in the composition of the jury pools, Batson versus Kentucky, which says that prosecutors theoretically can't strike on the basis of race, that other things that the Supreme Court had held, and the Georgia death penalty statute and the aggravating and mitigating circumstances and the way it decided or it guided how the death penalty was to be imposed. It said because these procedures, Georgia had minimized the risk. Now this is an important point. Notice it didn't say the procedures had to work. It only looks at whether there are procedures that minimize the risk, and if there are such procedures, stop right there. And that's what the court did in Dobbs' case. What it really says is that as long as these procedures exist, and they don't have to be implemented in the case, it doesn't have to be invoked in the case, the court is going to reject a claim of race discrimination. Today, virtually impossible for a defendant to get even a hearing on a claim of race discrimination, even though everybody knows that race is playing a role, very often a dominant role, on the question of do we seek the death penalty or do we not. We know that the prominence and the race of the victim is a critical factor. We know that the race of the defendant is a factor, particularly interracial crimes, particularly if there's sexual assault or behavior like that involved, and there's some politics involved as well too. Those are all extra legal factors that shouldn't be considered, but they're very much central to the decision to seek death in many cases. Let's talk for a moment about Dominic Green's case in Texas, where he did at least get an issue of race discrimination before the Texas Court of Criminal Appeals. This case involved a crime committed by 4 people, 3 blacks and 1 white. 2 of the blacks who participated in the crime made plea bargains and got out with prison sentences. The white fella, he didn't get charged at all, so he walked away free from this crime. Green was sentenced to death. And the prison people, the jail people, intercepted some letters that he wrote to one of the other fellows who was accused in the case, repeatedly using the word, sort of the rap word, nigga, N-I-G-G-A, and he signed off the letter as a trigger-happy nigga, and that was presented to the jury. The case went up on the argument that this was not necessary to put this letter in, but the Texas court held that the probative value outweighed any prejudicial effect and that it was properly admitted at Green's trial, and Green was put to death. Let's look at John Bass's case. This was a case that points out the problem of getting information. The United States government has been prosecuting capital cases since 1988. And we know that the federal government prosecutes death penalty cases more than twice as often against African Americans than against whites. Really quite remarkable, and the federal death row is quite remarkable, and it's overwhelmingly people of color. Also, the Justice Department plea bargains more often with whites. In other words, in that second decision that prosecutors make, we know that federal prosecutors are more likely to offer a life sentence and allow a person to escape the death penalty if they're white than if they're black. All this information is presented to United States District Court, which says, well, we need to look into this. We need to require the prosecution to provide some information about its charging practices so that we can see if there's some explanation for why it is that more blacks are charged, that blacks are denied plea bargains. That's upheld by the United States Court of Appeals for the Sixth Circuit. But the United States Supreme Court grants certiorari and summarily reverses the case. And basically says that Bass has not made a credible showing of discrimination, that the raw statistics, which are the only statistics he can have because he doesn't have the information that the court had ordered be disclosed, but it says all this is raw statistics. It shows they're seeking the death penalty more often against blacks. It shows that they're giving plea offers more often to whites, but that alone doesn't really tell you anything because in theory, there could be some other explanations for that besides race. Another case involving information was in re United States. This was a fellow named Williams who was one of 14 people who was indicted for a terrible crime. They were smuggling people into the United States in the back of a truck, and as a result of the heat and the failure to adequately take care of these folk, 19 people suffocated, died in this truck. And there were 14 people indicted for this, but they only sought the death penalty against one, and that was Williams. And so Williams, of course, raised this with the court. Why me? Why am I the one for which the government's seeking the death penalty when there are 13 other people who were involved in this smuggling operation just as I was? I'm not saying he shouldn't be punished for what he did, but why is the death penalty being sought in his case? Judge Gilmore, the United States District Judge, this was a federal prosecution in federal court in Texas. The district judge said that she wanted the Department of Justice to give information about its sentencing practices to the defense so they could make an assessment of why it was that Williams was charged and not other people. And Williams also pointed to these larger racial disparities in the use of the federal death penalty. And then when the government wouldn't turn the information over, Judge Gilmore said, well, I'm going to instruct the jury that I asked for this information and the government refused to give it. This is sort of like a missing witness instruction. Sometimes if one side has the ability to call a certain witness and doesn't call that witness, the court will give an instruction saying the jury can draw some inference from the failure to present the witness. Mandamus relief is very unusual and only for an abuse of discretion and almost never granted against district judges. But here, the United States Court of Appeals for the Fifth Circuit issued a writ of mandamus saying that Judge Gilmore could not give that instruction and said that she had abused her discretion and therefore prohibited it. As it turned out, the case ultimately did go to trial. Williams was not sentenced to death. But here again, we see the courts just simply unwilling to give up any information that might explain the racial disparities. The case that sort of is the genesis of all this, the case called Armstrong versus United States, which had to do with the disparities in drug sentencing with crack cocaine and powdered cocaine. Once again, a district court had ordered disclosure. It had gone up to a court of appeals, but the Supreme Court of the United States said, no, you couldn't get the information. Of course, if you can't get the information, you can't prove your case. So the court has done two things with regard to race claims and race cases. One is set a very high standard that exceptionally clear proof that the defendant has to show because of and not merely in spite of. And secondly, deny the evidence. In these cases, the court has said we're not going to look into the reasons for the prosecutor's decisions. We're not going to require the prosecutor to give us information that might help us understand why certain decisions were made. The result is basically that even though race plays such an important role in who's sentenced to death, which cases advance to death penalty or are seen as death penalty cases, advance to penalty phase and deaths imposed, the courts almost never now, based on McCleskey, look into why it was and what prosecutorial decisions were made and whether race influenced those decisions at all. The last case, State versus Dorsey, this is the monument out in front of the courthouse in Shreveport, Louisiana. That's Cato Parish, where we have Robert E. Lee and Stonewall Jackson and Jefferson Davis, and then we have sort of the every man sort of soldier for the Confederacy, as well as the Confederate flag. One of the jurors, one of the African-American jurors who passed by that going in the courthouse said, you know, I don't feel very comfortable coming into a courthouse that has this huge, and you can see this is not just a little plaque or something. This is a huge monument, concrete monument, maintained there in front of the courthouse, right where you come in. He says, I don't think that's right. These people were in rebellion against the United States of America, and they were in rebellion because of race. And so he was excused from jury duty. Dorsey's lawyers raised the question that race came into play in his case because, of course, all the jurors, black or white, had to go past this symbol of the Confederacy. But the Louisiana Supreme Court held that did not in any way interfere with his trial and affirmed his death sentence. There has been legislation passed in just a few states to deal with race discrimination since the courts are not dealing with it. Kentucky passed a Racial Justice Act. North Carolina passed a Racial Justice Act and actually had hearings on it, 2 hearings, one involving one person sentenced to death and the second hearing involving 3 other people sentenced to death in Cumberland County, North Carolina. And the findings made, as will be discussed with Henderson Hill in another segment, were really quite striking. It's one thing to look at the jury strikes within a particular case and see that there's a disparate number used against black as opposed to white prospective jurors. But what happened in the Racial Justice Act cases in North Carolina was they put together all of the jury strikes in death penalty cases in North Carolina. And when you aggregate all those numbers and you see that over the course of the time since North Carolina has had the death penalty, a black person is twice as likely to be struck from jury duty. When the prosecutor has a chance to strike a black person, it's twice as often that they're going to strike a black person as a white person. The court also found that the race-neutral reasons prosecutors were giving were often not only pretextual, but it came out in the hearing that the prosecutors had a cheat sheet. And they had the race-neutral reasons already written out before they ever saw the jurors. So when a prosecutor struck a black juror, and under Batson versus Kentucky, the judge, if it was challenged, the judge would say, what was your reason? You just look down and say, that person looked distant or sullen or some other race-neutral reason that had been supplied before you ever saw the juror and the way the juror behaved. Judge Weeks found that prosecutors in North Carolina, instead of trying to study how to present their cases to diverse juries and how to have a fair system, had instead tried to figure out how do we resist the Batson versus Kentucky decision? How do we continue to exclude black people from serving? In both cases, he found that race had been a factor, which was the statutory language. Race had been a factor in the imposition of the death penalty. And under the statute, the 4 cases the sentences in the 4 cases were reduced from death to life in prison. What did the North Carolina legislature do? Upon finding that race had played such a dramatic role in death penalty cases, it repealed the Racial Justice Act. And so now people in North Carolina who had the opportunity to make claims that McCleskey basically barred everywhere else, but North Carolina allowed by its statute, can no longer make those claims. Finally, in federal cases, federal jurors are required to sign a statement and are instructed that they're not to let the race of the victim or the race of the defendant come into play when they make the decision. Whether or not this is very effective in preventing race from coming into play is subject to debate. But overall, as we look back on what we've talked about in this segment, we see that the reluctance of courts to deal with race, certainly in North Carolina, we see the reluctance to deal when race is proven, to repeal the law so that it can't be proven anymore. And North Carolina was the only, and Kentucky, the only states that have passed racial justice acts. So claims of race discrimination are seldom, if ever, going to be heard in the courts, despite the fact that race is such a prominent feature of the death penalty, always has been and still is today.